utility. They can be purchased to swap and trade. I think
Oh man, we're here to cover off the SEC versus the Coinbase live stream, guys. I've got the court hearing up right now. Hopefully you guys can hear it. Let's just play that and get straight into it. Shout out to MeetKevin for the audio stream.
in which one of the objectives is investment gain.
All right. So you just said a moment ago you actually want to join with the commission on actual arguments and not some of these more esoteric or theoretical matters. So what are the arguments in which you join? Your arguments are that the transactions alleged in the complaint are not themselves investment contracts. Not that there couldn't be, but that these aren't.
That is our argument, Your Honor. And as I said a moment ago, we don't take the view that token transactions on primary or even potentially on secondary markets can never be an investment contract. I think we could have a conversation in which we could imagine transactions that would look like investment contracts, but it requires allegations of fact that are missing in this complaint. And to be clear, we want to give the full perimeter to the Commission's position on its pleadings. We know that the court will give every inference that's reasonably drawn in their favor. So we want to give those inferences because we think even with that perimeter, we have arguments that should prevail, which is the point I was trying to make about not wanting to draw a caricature of the position on the other side, but to give it its full berth.
No, much appreciated. Thank you. So according to the commission then, as I look at these transactions in the secondary market through Coinbase, through services offered by Coinbase, I don't just look at the purchase of the asset, I look at what the purchaser is getting. And according to the commission, the purchaser either is aware of or could be aware that one of the reasons that the buying this token buys into the ecosystem, the goals of the issuer, whether they be to build a better blockchain or to develop apps for that blockchain, or otherwise promote whatever the blockchain is. And so what they're suggesting is that by dint of there being statements from promoters and developers and issuers, and by dint of those statements being included on Coinbase's platforms, that I can understand, at least for 12b6 purposes, that a reason that that customers are buying these tokens is in order to advance the goals of the issuers, to join that common enterprise. Could you tell me, please, why they're wrong?
Well, I should say, I don't think all of that is wrong.
Okay.
And here again, this is in the spirit of trying to flesh out the position on the other side.
Yes, I'd like to know what you agree with and what you disagree with. Thank you.
We think so much is true for purposes of today only, for purposes of the pleadings only. It's alleged that there are purchases on the secondary platform in which buyers buy tokens with knowledge of the statements of intent of promoters with respect to the things they may hope to do on their blockchain or otherwise with the token that they've issued. And that those statements may well be in the understanding or consciousness of a buyer when he, she, or it purchases the tokens. Whether that constitutes buying into an ecosystem is something I don't know that we believe is adequately pleaded. I'm not quite sure what the phrase buying into means, and we're at a point where matters, where distinctions like that I think may matter. But we would acknowledge this. You have the purchase of an asset, and what it's accompanied by are statements of promotion, statements of intent by a promoter, which a buyer might believe, if they were followed through on, which they may or may not be, could create a rise in the value of the relevant investment. So to that extent,
For those just tuning in, guys, remember this is the SEC versus Coinbase lawsuit where the SEC are trying to say that Coinbase is acting like an unregistered exchange. Coinbase is going to come out and do their bit, but it may be that the judge dismisses this tomorrow. We may not get a verdict today, but let's stay tuned to see what happens.
sections of the statute in which it appears, or within the contemplation of the contract, that can constitute an investment contract. So I think the answer there is no, there isn't enough.
And what is it Right. So I believe the commission is suggesting, and I'm going to very much minimize and dumb down their position, but they're suggesting, as you were just saying to me, that the purchase of an asset with knowledge of the statements of intent could lead one to believe that the person is purchasing the asset as some sort of espousal of or hope to continue whatever those statements of intent are. If your token is going to change the world in some great way, by buying your token, may say, I agree, I think you should change the world in that way, and I hope that you do, and I hope that all of that leads to an appreciation in the value. For you, sir, for your team, that is not enough. I'm saying what's missing, and you're going to say some contractual, some ability to enforce, and I want to understand what does that mean, and I am asking you to describe it at its most basic level so that I understand it.
Completely fair, Your Honor, and understood. There were, in a sense, before getting to that, with apologies, Your Honor said that the SEC's position involved buying a product to advance the interests or the ideas of the promoter, and I hear that.
Well, let me be more specific, because I don't think I was complete, because I think in so doing, they're doing a couple of things. They are, number one, joining the common enterprise of that issuer, of that developer, and number two, they are doing so with the hope that there will be some gain in the form of token appreciation as a result of that purchase. So it's not just, you're not, for some reason I'm thinking about those folks who pick the NCAA teams based on the color of the uniform or something like that, with no, and I'm not saying I was those people, but I'm not saying I was those people, but I'm just saying, so you could pick a token because you think it sounds really cool, or because your friend has that token and you want to be just like your friend. But I think what the commission is arguing is that there are purchasers through Coinbase who are looking at a token, looking at the developers, looking at what the issuer hopes to do, and aligning themselves with that, and thereby they say joining that enterprise. I thought that your position was that there's an absence of on the part of the purchaser some way of enforcing that or getting something from that, and that's the problem. But I'll let you speak.
She's feeding the argument to them.
Say that, and our friends at the front table picked on us a little bit this morning on this, but we deserve it. It's the right question to push on by the commission and the court. What we say, and we think this is truly faithful to the statute, truly faithful to the securities laws and their purpose, and truly faithful to the cases, is that what is required, at least at a minimum, is the holding out of an offer of an investment that includes a statement meant to convey to the offeree some sort of enforceable right. At a minimum, that much is required as a securities law matter.
And so, just to play dumb here, what does that mean? I mean, I guess I'll ask. You heard me ask Mr. Costello whether the logical extension of his argument was that purchasers of these tokens suddenly got rights under the securities laws. I'm asking you the converse. You're suggesting, if I bought Sol or one of these tokens and it went belly up not because that's just the way the world is, but because of something bad that happened by company management, which of course I'm not saying is actually happening, am I just out of luck? Is there, or am I limited to common law, contract, and tort rights, but just not rights under the securities laws?
Very much the latter, Your Honor. That is to say, the purchaser of Sol in the court's hypothetical would have claims sounding in fraud, were there a fraud, and there may or may not be. It's conceivable would have claims sounding in contracts, although it doesn't.
But you've just said to me there's no enforceable. I mean, we're talking about a situation where there is.
He's burying himself.
Statement of enforceable right, which would suggest there is. What's the contract then in this attenuated transaction between the purchaser and the ultimate issuer of the asset?
And it's a great question, Your Honor. I should be clear. So fraud, of course, we don't have the contract problem. It's a tort, as I know the court knows. And the most natural place where there might be a cause of action in that scenario. If there was fraud, was fraud. And the court no doubt has seen when it's reviewed the investment contract cases that some number of them either decline to find investment contracts but say there could be a fraud claim, or find fraud claims under common law in addition to an investment contract. One could imagine a scenario where there was some sort of contractual relationship between the buyer of a token and a promoter that was not sufficiently linked to the investment that it would constitute an investment contract. They could have contractual relationships otherwise than constitute an investment contract. But the real bottom line we want to push on is that there is a distinction between the securities laws and the law of contract and the law of tort.
He's overcomplicating.
Mr. Costello made reference to the Joyner case earlier, and it's an important one, I think, and it informs much of our thinking and perhaps much of the commission's. In that case, there was some question whether there was a state law contract claim. And it's very interesting when one traces it through the lower court decisions and you see that what's happening is a debate amongst the circuit court about whether there's an implicit contract or an explicit one. And the Supreme Court, as the court saw, found it unnecessary to resolve that question, because what it found was that there was a sufficient holding out of a contractual relationship that satisfied the securities law test, so as to render the precise state law contract question unnecessary for disposition. Judge Boudin says something to the same effect in the Rodriguez case.
What? He's burying himself.
And that it's that sufficient holding out of a contract is what you find to be missing from the transactions at issue here.
In candor, Your Honor, that's a little bit of an understatement. We think the complaint is truly devoid
better.
of anything that could plausibly
Better.
to a promise that's enforceable by an issuer to a secondary buyer on Coinbase's platform. And
way better.
And I'll raise, and I hope it's helpful to raise it at this point in our conversation, a couple of cases that really came to mind when you were chatting with Mr. Costello on largely this subject.
Just a reminder, guys, we are actively trading this market as well. I've got my phone here on the side. We are just taking 20% profits on our Treeb trade. At least some people got up to 26% profit on spot. Just take profit one. Join us, link in the description.
Electricity, and they were going to build roads. There was going to be a country club. There was going to be a meeting house. I don't know what. There was going to be all sorts of stuff. There was a thing called Rancho California in Southern California. This is the Duluth case. It was going to be great. It was going to be great. And then there was the Disney World developments near in Florida that were at issue in Rodriguez, and those were cases feel a lot like the argument that we're hearing here, Your Honor. There's a promoter. The promoter is making promises that it's going to develop a real estate ecosystem. Those promises were on their face not enforceable by the buyers. And when the sales were made, and in retrospect, the buyers were aggrieved by their purchase, they sued under the securities laws and said investment contract. And the court said no investment contract. And the reason was that promotional statements aren't enough. Even promises in the ether aren't enough. There has to be sufficient undertaking of an apparently legally enforceable character so as to give the buyer a claim. That's what those cases said in what we think are highly analogous circumstances. And I don't think there's any surprise in that. It is, to return to first principles, Your Honor, if the words are investment contract, it oughtn't come as a surprise that people look for a contract. And that has always been the touchstone.
Sure, but then we've got the whole scheme argument.
Well, we do have the scheme argument, Your Honor, and that's what we thought we were going to be confronted with when we came to visit with you in July.
And we weren't.
And we weren't. And we think there's a reason why, Your Honor. We demonstrated, we think, to a fairly well, that the only way to understand the word scheme as it appears in Howey and has been echoed down now through the generations is as part of a scheme of contracts, a series of transactions and contractual undertakings that taken together constitute a whole. We were so confident we were going to be confronted with that argument, we addressed it in our opening brief. And it was met with stunning silence. That argument went off stage, left, never to return. And we don't think that's in the case anymore. We certainly don't think it's a position that's been defended in the answering brief, and we think the reason is clear: it can't be. It's not what the blue sky cases taught the investment contract meant. It's not what Howey meant when it brought in the blue sky cases, and it's not what's ever been meant in the cases since then. Every one of which, Your Honor, every one of which, putting aside at any rate the recent crypto enforcement blitz, every one of them has involved a cognizable contractual undertaking, no exceptions. And Your Honor, that reminds me that I was remiss in failing to ask you whether, notwithstanding the character of the argument, we could hand up some slides that we made that bear on a couple of issues we might want to talk about.
I'm sure someone stayed up through the night putting them together, so yes, please.
Thank you, Your Honor.
I'm sure they're wonderfully done, and I appreciate the effort, so yes.
She is so nice
With the folks at the front
to
table.
Coinbase. She is giving everything to Coinbase here. She's handing this win to Coinbase so far. And now she's letting Coinbase present with slides. She agrees.
Just want to cover this off, guys, to give you the TLDR for those who have missed out so far. This is an update from Meta Lawman, who's actually on site at the court hearing. The dial-in number is for the US. I'm taking MeetKevin's audio feed. Shout out to MeetKevin. I'll leave the link in the description. Not that any of you guys probably don't know who he is in the stocks and finance space, but take a look at this. SEC versus Coinbase update so far. In an unusual move, the judge dispensed with any prepared arguments from either side and instead went straight to questioning the lawyers. The first 2 hours, which before we jumped on, spent exclusively questioning the SEC lawyers. The SEC lawyers were better prepared. Remember, they weren't very prepared in the initial pre-motion. The questioning started with staking. Of course, staking is one of the issues, right, which the SEC want to go after. Then went into how the Howey test, which I had up on screen a second ago, applies to crypto, and finished with the major questions doctrine. The judge is super sharp on these issues and asked very precise questions she had prepared in advance. The judge said she had not decided anything, had an open mind on these issues. The judge repeatedly referenced the amicus briefs filed in support of Coinbase. She said she found particularly significant that Senator Loomis has filed a brief saying that Congress needs to decide the issues in the case, including how crypto assets will be classified and which agency will ultimately have authority. Remember, this is not just a Coinbase issue. One of the reasons we're tuning in and sharing this with you guys is this is not just Coinbase. We've got the Coinbase price up here. You can see it fluctuating around during the court case, but this is actually them taking a stand for the whole of crypto. This becomes a precedent that will be then set for the whole of crypto. So it'll be very, very difficult if the SEC win this motion. So all the crypto industry is behind Brian Armstrong and Paul and his legal team to win this and set an example, and so far so good. Like as you heard there from MeetKevin, who jumped in on the prelude, the judge has been quite favorable in terms of Coinbase's stance. Remember, Coinbase is the teacher's pet, right? If Coinbase aren't doing right by the law, who is? Which exchange is? They registered on the NASDAQ, right? They're in America. They're trying to be the teacher's pet, publicly listed. We want to follow all the rules. SEC, let us walk in, let us register. They reject so many different altcoins to say, look, they don't meet the Howey test. They do their own checks. They got their own balances. They're saying, hey, if we're listing securities, no way. Like, tell us how. And that's how we got to this point. So let's check back in now.
Those matters.
Before we put this to the side, sir, there are other slides you want to call to my attention at this stage?
Not at this stage.
Okay, thank you.
Thank you.
I'll keep it nearby just in case. Thank you. Sir, I want to actually back up. I know we should be going forward, but I am moving backward. I had extensive discussion with the commission about what conduct of Coinbase, what it is that your client actually did that brings them here today. And part of the reason I was asking that question was to figure out whether there were factual disputes that foreclosed a motion to dismiss based on the conduct alleged, or whether everybody agreed on the conduct and they disagreed as to the legal import of that conduct. Are there, I know from your submission, I know from the DeFi folks' submission, that there is some dispute about what actually is involved with the wallet program and with the staking program. But perhaps including that, are you accepting the commission's allegations of Coinbase's conduct and saying that they are nonetheless insufficient based on the argument or the discussion we've just been having to implicate the securities laws? Or are you saying otherwise, that there is a dispute, but it's obvious from my read or my ability to read materials of which I can take judicial notice or that are fairly implicated by the pleadings, the complaint, that I can determine that your view of Coinbase's conduct is correct.
I think, Your Honor, for purposes of this motion only, we are accepting the allegations that the complaint is true. I do hasten to add that they need to be well pleaded, and by that I mean that they have to plead facts rather than conclusions.
Well, of course, yes.
And that if they rely on a document, the court can and should resort to that document to verify the well pleaded character of the complaint. But we've worked very hard to accept the pleadings as true and to create for the court a pure question of law in respect of the investment contract issue, and I think as Mr. Schwartz will say, in respect of the wallet and staking issue as well.
Okay, and perhaps that's where these factual discussions are going to be had with greater detail. I guess I'm asking, and perhaps it's too much to ask of you, like right now as you're sitting here, are there factual disputes? Are there things that you are thinking to yourself, the commission completely got it wrong, and if Fela would only look at the underlying documents, she'll realize that they got it wrong? Or, and maybe that's really, to me, the disputes were most acute and pronounced in the discussion of the wallet and the staking programs. But if, for example, in other areas, there's something that you want to call to my attention, please tell me that now.
I think the answer is no, Your Honor. We talked, for example, about paragraph 65 of the complaint and Asset Hub, but you have our position, and that's an example where I think there needs to be at least a jot of critical scrutiny attended to the pleadings and what they actually fairly put before the court. I listened with great interest to your discussion with Mr. Costello about the scarcity potential in commodities and having failed to get a complete set of baseball cards many times as a child. I can tell you that certain cards are always withheld to create scarcity and drive value. Whether that's a factual issue, I don't know, but we aren't going to accept, for example, without a fight, the idea that things like Beanie Babies and Star Trek memorabilia and baseball cards aren't part of an ecosystem, to use Mr. Costello said. I think that is fair ground for debate. So I don't think that's what the court was alluding to, but we could join issue on something like that.
I'm grateful that we're all not taking the tangent of thinking about our favorite collectibles and using those. But I appreciate that. Thank you. Okay,
She's being super polite to Coinbase.
I wanted to make sure I understood where the parties agreed or disagreed as to the conduct. I mean, just in that vein, sir, there's a lot of discussion about what Coinbase supposedly does or doesn't do. And in particular, in your answer, your client and you, by extension, are extremely careful in parsing each allegation of the complaint to let me know what you agree with, what you are disagreeing with, but it doesn't really matter, what you're absolutely denying. And I appreciate knowing that. I am just wondering about the degree to which that matters for this motion. And my sense, the more I speak with you, is that it really doesn't.
Well, I think it does not matter critically. We agree. And that's because I think this really can be boiled all the way down to the question whether the sale on a secondary market in a blind bid-ask transaction of a token where no rights or obligations travel as part of that transaction can be an investment contract, as that term appears in the statute and in the case law, on the strength of the statements of intent or promotional statements that issuers have made. I think the case, at least this branch of the case, boils all the way down to that.
And on that point, my understanding of my conversations with Mr. Costello is that he believes that Coinbase is just being a bit too literal or too centurion about what that means, and that they're not suggesting it needs to be a written contract or a formal document, and you're not suggesting it either. What he's saying is, though, that there is an implicit relationship, an implicit agreement, or at least accession by the purchase of the crypto asset in a situation where there's discussion or a lot of submissions or I guess white papers and such on the part of the developers to what's going to be done with this crypto asset. I think you're saying to me, unless there's some mechanism of enforcement and all of that very lovely promotional and marketing language, it just doesn't matter. Do I understand that correctly?
I think that's fair, Your Honor. I mean, to give even a little more ground, because we want to make, for purposes of this motion, our position capacious, there has to be, in the transaction that constitutes the sale of the asset, there has to be at least as part of that offering, there has to be a statement that is meant to convey an enforceable promise. That's the irreducible minimum of what could be conceived to be an investment contract, knowing that we're talking about contracts in the securities law context. If you don't have that, then you don't have a contract of any kind anywhere in the vicinity, and therefore you don't have an investment contract. And here again, I would keep coming back to the real estate cases, where you had all sorts of blandishments and suggestions about what was going to be built out. And the courts, one after another, said not enough. I talked about Deleuze and Rodriguez. The Reback case in our circuit is of a similar ilk. It didn't go off on the investments of the efforts of others element, but rather on common enterprise, but insisted on collateral agreements. It insisted on collateral agreements, finding none. The Second Circuit rejected the investment contract claim. So we don't think it's fair, reasonable, or sensible statutory interpretation to say that you're insisting on too much when you're talking about an investment contract to look for a contract. And the SEC has said that itself more than once. The Supreme Court has said that itself. These cases all come out the same way. And what's marked here, in our judgment, Your Honor, is a departure. We've been criticized a little bit, I think, from our friends at the other table for saying the rules of Howey and its logic and reasoning don't apply to crypto. I think the shoe's on the other foot. I think what's exactly being promoted here is a view of what an investment contract is and has been understood to be under the cases and within the statute that's completely different than has ever been the case. It is not we who are unwilling to faithfully apply that statute and that case law. It is the Commission. They are trying to stuff these transactions into the investment contract rubric when it's perfectly plain from the words of the statute and the decided cases and the chair's statements that they don't belong there. We think that's what's happening. And it's a really important issue, because at the end of it, agencies have authority, and the Commission has broad authority within the world of securities to regulate, but it does stop at the water's edge. And if it doesn't, one is casting about for a limiting principle. And I think the court has cast about for a limiting principle. We can talk about that as well, but I don't actually think the court's heard one. And I think it's a very big problem.
Well, actually, that you're anticipating my next question. You've obviously been paying attention. You saw my lengthy discussions with Mr. Costello and the concerns that I had and my request for a limiting principle. He's given me some. You don't accept them.
Well, a couple
because
things.
They're not contract-based.
Well, you asked for a limiting principle with respect to whether private plaintiffs could bring suit, and I don't think you did get one. I think you were told that they could.
Yeah, I think that was what I was told.
So that request for a limiting principle was met with the response, no, thank you.
Well, no. Let's be. We'll both be fairer to Mr. Costello. What he said was that it wasn't by itself, and to the extent I'm thinking of it as sort of an opening the floodgates to letting all of this in. The putative private plaintiff would still have to satisfy the securities laws. There'd have to be some allegation of a purchase or sale or fraud or something big, warranting rescission. So I accept that I overstated the amount of private plaintiff actions that could be tied to my decision in this case, although there are some. He's at least admitting of the possibility there are some. So yes. So on that limiting, I have a limit. It's just, it's rather expansive, but I have a limit. The bigger issue, and the issue with which I was discussing with Mr. Costello, is my concern about this idea that simply looking at the promotional materials of an issuer somehow makes the transaction an investment contract. That purchase with knowledge of or with reading of these materials makes it an investment contract. What I was told, I believe, and he'll tell me in his summation part, is that it's more than that, and there has to be some sense that someone is buying in to the ethos or the ecosystem of the issuer by purchasing that token. Now, that may get them through 12b6. Who knows what happens at the Rule 56 stage? But I believe that to be the limiting principle that I was given. I'll ask you to tell me whether I misheard and whether it's enough.
Your Honor, I think you did. We heard the same thing, so
Okay.
I do think that that's the Commission's position. That's how we understand it, and we don't think it's enough. We don't think it's enough for a couple of reasons, which I'll try to summarize. The first is we're deeply unpersuaded that it is or has been shown to be an actual limiting principle.
That was good for Coinbase.
The idea that by purchasing what is, after all, just an asset, one buys into the ecosystem can be said about very nearly anything, because nearly every commodity of value, nearly every collectible one can imagine has an ecosystem around it. It doesn't really tell you whether you're in or you're out. And I want to circle back to the question of the conceptual and the practical implications of this. So I'm going to jump on that before I shut up, if that's okay, Your Honor.
Go ahead.
But what I wanted to say before getting to that is we've offered two limiting principles, and we don't think they're parsimonious. One is that if it's an investment contract, there needs to, at least to be the offering of something that's meant to be a contract. That seems fair. We've also said that a further limiting principle is that the investment needs to be in the business. And I think the Commission allied that point by saying it needs to be an investment in the ecosystem. But I don't know what that means. It means a statement of affiliation with it, perhaps, but let's be clear, at least on the secondary market, which is all we're talking about, Your Honor, no one is giving anything to the promoter, period, full stop.
Fair enough, but Justice O'Connor says in Edwards, profits means the profits the investor seeks on her investment and not the profits of the scheme in which she invests. How do you square that with the argument you've just now made to me?
She's on it. She's on it. She is
I
good.
think it squares well, Your Honor. I want to talk about Edwards a little bit because to state what I'm sure the court is fully aware of, Edwards was a case in which the 11th Circuit found that an investment contract could not be had in circumstances where the investment contract promised a fixed rather than variable return. That created a circuit split.
Right.
In retrospect, anyway, it's a peculiar holding, given that it's pretty clear that the securities laws reach fixed income investments. So the Supreme Court reversed. The question before the Supreme Court was this: is the profit or the payout that has to be available in the investment contract context one that is tied to the profitability of the enterprise? And the answer to that question, stated that way, was no. And the reason was, is even if the Edwards business wasn't terribly profitable, or it was less profitable or more profitable, a fixed return could issue. It was okay to have a fixed return in the context of an investment contract. That's what Justice O'Connor was saying there. I appreciate that plucked from that context, that appears to suggest something else, but it is not consistent with the rest of that decision, as I'm sure the court has seen. And I would remind the court that in the Edwards opinion, the Supreme Court went out of its way to say, this is just the way the SEC has been interpreting this all the way along. And, Your Honor, we looked at our second slide about what the SEC told the Supreme Court was going on with an investment contract, including a contract which is an agreement between several parties. And it's really important because Justice O'Connor was saying you can get a payout in an investment contract scenario that is not commensurate with the profitability of the enterprise if the contract is so structured. But it was not saying that the profit or payout could be untethered from the capital structure or invested proceeds in the company simpliciter. That makes no sense in the context of that case or the long, long line of Supreme Court cases that preceded and followed it.
All right, but I feel like we're talking about two things. You're talking now about tethering to the capital structure, and earlier we were talking about the rights of the putative purchaser to enforce. Help me with that, because I think they are two different things, yes?
They are two different things, though one of the truly fascinating and head-hurting parts of this case is the more you think about them, you see real points of intersection. But the answer is yes, they are.
Okay.
They are at least two very distinct ways of holding the problem up to the light to understand how to think about Howey and the contractual provision. And I do think the relevance, the reason, Your Honor, and with apologies, the reason I addressed Edwards in that way is I perceived the question about that statement to go to that issue, but perhaps wrong.
So you're absolutely, no,
Yeah.
you've not misunderstood anything that I've said. I just thought it was interesting that we ended with the discussion about tethering to the capital structure when we began sometime earlier with discussion about enforceability. I wonder if you could pause for a moment, sir, and talk with me, not to me, about the decisions this past year from Judge Rakoff and from Judge Torres. And why don't we all just stipulate, lest we be accused of either complimenting or criticizing them unduly, that these are hard issues. And maybe they came out differently, maybe they didn't come out differently, maybe the decisions can be reconciled. But I want to, for example, with respect to the Terraform decision, and in particular the motion to dismiss, I think there was some discussion about the need for some sort of contractual right, and I thought that Judge Rakoff wasn't really feeling it, as it were. But I acknowledge that Terraform is quite different from the facts of this case. Separately, I myself, I'm following Judge Torres' decision, and it's on very difficult subject matter. Although I think I tripped when I got to the primary secondary market transactions distinction. And when you began your discussions with me by talking about the blind nature of the buys and sells here, I thought, I have to remember to ask him about that and how, what importance he ascribes to that distinction that Judge Torres has found in her decision. So that's a very long question. I'll try and do better this time around. Let's start with Terraform. Is Judge Rakoff right or wrong?
So now she's coming on to Terra Luna.
Ooh.
I don't know.
Okay.
It's a very different case. I think we disagree with meaningful aspects of Judge Rakoff's analysis. There's a big however, which is...
Right, because he then finds, I thought he found that the asset was not itself a security, but it could, the asset was not itself an investment contract, but could be used in an investment contract.
I do think that was part of what Judge Rakoff was saying there, and though we would probably disagree with certain aspects of his holding out of view, when you put the decisions together, the motion to dismiss and the summary judgment decision together, we think even if that mode of analysis were applicable here, our motion here would survive. And let me say why. But the Terraform case, first of all, as I know the court knows, did not involve secondary market transactions. There were no secondary market transactions in that case. The SEC went out of its way to tell the court that it wasn't dealing with secondary market transactions. Those were all situations where there was a relationship of privity between the investor and the promoter. It's a very important point of distinction. The Judge Rakoff said ultimately in Terraform, and I think I have this right, that no formal contract was necessary to form an investment contract. Fine, we agree with that. What's required in our judgment is a showing that the promoter held out the promise of something meant to convey a contractual promise. But Judge Rakoff does allow as follows, and I think these are his words: an investment contract at a minimum requires the contracting parties to agree or scheme together that the contractee will invest in the contractor's profit-seeking endeavor. Now, that would probably be a point of disagreement between the way we're framing this matter and are litigating it to Your Honor, and the way we think it's going to be rightly decided in Judge Rakoff, but we can live with his formulation. And the reason is that the SEC in this case hasn't alleged anyone agreeing or scheming together to invest in the contractor's profit-seeking endeavor. The allegations here show no agreement of any kind as between these trades on the secondary market between strangers to invest in any contractor, that is to say promoter's business. And there's still less is there any kind of agreement that the buyer's payment would be invested in that that business. So that's one point I really wanted to emphasize about Terraform. A second is moving to the summary judgment ruling. The texture of that decision seemed to us to be quite a lot different. And while the court did enter summary judgment on the investment contract issue, it did so, first of all, on the basis of recognizing some contractor-contractee relationship, which I just said. And it also went out of its way to emphasize that there were ongoing relationships and obligations with respect to the token. So as to the UST token, which is the dollar denominated, the dollar pegged token, the court relied on the fact that the token could be deposited into the Anchor protocol and earn pro rata interest or dividends, thereby demonstrating that that investment was one that was in the ongoing enterprise. As to Luna, the court relied on the representations of the company that the token carried a claim to a distribution of transaction fees, again, proceeds coming from the enterprise to the investors in a relationship of privity. And similarly with the Mirror Protocol token, the court found that it earned fees from asset trades. And so we might have a lot to quarrel about with Judge Rakoff's decision, but the truth is we can live with its analysis because it recognized ultimately that there has to be a contractee-contractor relationship, and there has to be some ongoing engagement with the assets of the enterprise. Nothing like that's alleged in this case, Your Honor. So that is the way we're holding the Terraform case.
That was strong.
Could you then speak to the Ripple case?
Well, Ripple starts with the correct first principles. Judge Torres says digital assets aren't securities, and then it goes on to analyze whether the various transactions are investment contracts, and there, as here, the question whether a security existed was strictly a matter of an investment contract. And what it found, what the court found in Judge Torres' case, was that applying Howey to secondary market trades could not give rise to an investment contract. That was what Judge Torres found. And now, we don't think all of the same arguments were raised here as in that case, but the critical takeaway there is that Judge Torres recognized that secondary market token purchases of XRP were not investing in Ripple. And in that sense, it rejected what I think is a core portion of the Commission's argument before the court today, which is it's investing in an ecosystem, at least with respect to transactions between strangers where no relationship exists, where no obligation to travel. That couldn't be said there, and it can't be said here. Ripple couldn't make any promises to those people because it didn't even know who they were. Same here with each of the 12 tokens it issued. These are blind bid-ask trades, and therefore, as a matter of law, Judge Torres held, and we think correctly on this, investment contract law didn't apply. These trades couldn't be investment contracts, and therefore couldn't be securities. And we think that branch of the whole thing, which was determinative in that case, as to the trades that are issued here, secondary market trades, it's a very close cousin of the issue right before the court.
Oh, yes, I understand that, and I think that's probably why the Commission disagrees with it so much. The issue here, I'm not disagreeing with your recitation of it. I guess I'm not familiar with, in other aspects of securities laws, in other cases that I've had, where the primary-secondary market distinction holds so much force, and where the notion, or indeed the fact that it's blind bid, blind ask trades matters so much. Am I wrong, or are there other areas of the law where it really does, where it has similar import? Here, I just don't remember having to focus on this in other securities cases I've done.
Thank you for that question, Your Honor, which is it goes right to the heart of what's interesting about this. Because let's talk about stocks. Stock, they trade in blind bid ask all the time, and no one would think to say it's not a security. A stock reflects an interest in the permanent capital of a corporation. And when it trades, that interest in the permanent capital of the corporation, which is a participation in its capital structure, transfers in entirety from one holder to another holder. Attached to a stock are a bundle of rights: inspection rights, right to sue, right to dividends, right to dissolution, all that good stuff. They transfer in their entirety from one seller to the other seller. And therefore, in every case like that, the issue doesn't come up because it doesn't matter who holds it. They hold the same bundle of interests, the same claims against the same entity, insofar as they are just trading interests in permanent capital. Much the same can be said about what trade commonly as notes or bonds. Investment contracts are different because investment contracts are assets stapled to obligations. And the relevant question in every case is going to be whether with the asset travels the legal obligation. You don't need to ask that question in the context of a bond transaction, Your Honor. It does. You don't need to ask that question in the context of a stock transaction. It all travels. These are different, and that's why. And it just won't do, given the requirements of an investment contract, we don't think, to say that it's the same transaction on a secondary market as on a primary market, because whatever may have traveled with respect to the ICO is not likely to travel in a secondary offering. But what matters for our motion, Your Honor, is it's not alleged to have traveled. And no one can say that in the context of a bond or stock sale.
We've had thoughtful discussions for a while now on the idea about the need for a contractual relationship and an ongoing engagement with the assets of the enterprise. I think in another section of your briefing, a distinction that you draw or an argument that you make is that an investment contract must share the essential attributes of other securities. I assume that that's just a variation on the theme, and that what you're saying is, for example, that you have to have something more than ownership of the asset. Perhaps you have some interest in the enterprise, perhaps you have something else. But I do want to make sure, when you're talking about essential attributes, and that is your argument, is that something different than what we've been talking about? And if so, what are the essential attributes that you think I should be looking for here?
I think what I'd say in response to that question, Your Honor, is first of all, and one looks at the definitional provision of the 33 and the 34 Act, the 34 Act as is relevant, I guess, for the 12 that we're talking about now. There are a list of securities. Investment contract is one of a bunch. And each one of them is an instrument that carries the legal entitlement to the proceeds, assets, or profits of an ongoing business enterprise. And so part of our argument is that investment contract should be understood to be consistent with that recitation, and that is what, in the words of the statute, makes something commonly known as a security, as opposed to buying the output of what a company makes. It's the difference between investing in Beanie Baby Inc. and buying Beanie Babies. It's the difference between those two things. Additionally, we call attention to the Judge Posner's Walls decision, which I'm pretty confident was picked up in the SEC's briefing in the Edwards case.
We talked about it earlier.
Yeah, and it talks about the essential attributes of a debt or equity instrument. And that, it's the same point, we think, but it's something different than the output of a company. It's debt, which is a senior contribution to a capital structure that's put to work by the company, or equity, which is the residual claim that is junior in the capital structure. And the things that are now being forced into the investment contract, we think are different because they play no part in the capital structure and they carry no claims against the ongoing enterprise and carry no contractual rights at all.
Just one moment, please. Thank you.
This is a very interesting argument, by the way, this idea that a security has something additional rather than just holding the asset, that there's some kind of right.
Just want to take this brief pause to walk you through this. It's very interesting. Go follow at Marty Party Music on Twitter. He says the following. So the Judge Failer, tells Coinbase lawyer the following: as I understood the assets, these tokens are never securities. The tokens themselves are never securities. The trading of these on the secondary market, like Coinbase, could be considered securities. And so what that segment just there was talking about was going back to the previous case, which another judge resided on with Terraform Labs, which you guys know about, Do Kwon. And so in that, they said that it was the ecosystem which made it a security, right? And this is what the conversation they're having is the ecosystem and the way it's being offered to consumers could be what's creating this packaged security. So like this guy said, Marty Party says, as I've been telling you, crypto on the blockchain is never a security. Crypto offerings on website platforms can be considered an investment contract, but that does not imply a security. Every offering will have to be evaluated individually as to its liability, disclosures, and classification of a security. This is about Coinbase and exchanges and how they offer crypto. It has nothing to do with blockchain tokens. So that's really important to understand, right? Like the native, going into a blockchain and crypto being minted is no different to you going into the ground and kind of mining for gold. Gold is not deemed a security. But if you were to package it up into some sort of asset class and then offer it, like a Bitcoin spot ETF, for example, then of course that deems itself a security. And so this is a bigger conversation for Coinbase and exchanges, more so than it is like a critical decision for the whole of crypto. But that said, of course, you still want exchanges to be able to list tokens on spot for people to go and buy, okay? So this is still a big deal for us, but just wanted to put that into perspective for you guys.
An investment contract. And it's not enough as a word of simple English when you think about investment contract, but it's not enough under the cases. It's not enough because, and here again, just to bang this drum, when you look at the real estate cases, you'll see they're very similar. And Judge Boudin has an analysis that says at some point, if the promises are enough and they seem enforceable enough, you might have an investment contract, and that's the holding of Duluth. There has to be something that is held out that's enforceable. That's what case after case after case says, and it's what's missing here. And it's really an important issue because there is no limiting principle otherwise, and that's because the vast majority of investments are going to be accompanied by someone saying something. But they aren't all securities. And the question is, what is and what isn't? You could have a situation where it isn't enough for the commission to say, trust us, we're not going to use this authority except when it makes sense. Because that can lead to a company thinking it was complying with the securities laws and then being on the receiving end of an enforcement action. That's a familiar scenario for us. It could also lead to any number of businesses believing they're operating with, essentially in dealing with what are non-securities and finding out that they're not. Because every commodity has promotional statements around it, and they aren't all securities. And what makes it different is the contractual undertaking that gives an interest in the business. If you don't have that, you don't have a security. So I'm sorry for the long-winded answer. The short of it is, you're right that we accept that there is an investment, and someone might think the promotional statements might, if acted upon, give rise to an increase. Our position is that's not enough, that the cases say it, and they say it over and over again.
Where is this in Howey? I mean, I understand from the securities law scholars that the precursors, the state law antecedents to Howey, speak about this, or at least they arose in that context. But the actual definition doesn't itself speak of this, either this contractual relationship or this obligation or means of enforcement or the ongoing engagement. So I don't know where it comes from, and I'd like to know where you're slotting it in the Howey test, if anywhere. And so let's start with that.
Yeah, well, it's a fair question. Howey only applies to instruments that constitute a contract, transaction, or scheme. And one answer to Your Honor's question is it's none of those things. It's not a contract. It's not a transaction. It's not a scheme. And we talked about how it's not a contract, and we've shown, I think, that it's not a scheme as that phrase was understood in Howey. it is true that we have chosen in our presentation to the court to not reduce Howey to 3 elements and then ritualistically go through each of the 3 elements. And we did that for several reasons. One is that, as I mentioned earlier, there's a great deal of intersection between the issues. For example, the need for a contract came up in the context of a collateral agreement in REBAC in the discussion of the common enterprise, but it came up in the other circuit cases in the context of the reliance for profit solely on the work of others. So these issues cut through, but they do not appear all the time in the same place, but they appear over and over again in the Howey jurisprudence. When the Supreme Court talks about Howey, it doesn't reduce it to 3 elements. It looks at the instrument in front of it, and it tries to figure out whether it fits within the traditional definition of a security. A lot of the circuit court cases do the same thing the Walls case does, and Rodriguez. We would broadly say this, that much of what we say about the need for a contractual undertaking demonstrates the lack of any adequate pleading as to the generation of profits from the efforts of others, because those cases all say that has to be something that you can go and get. At least has to be promised to you that you can go and acquire that. So it fits in there. And much of what we say about the SEC's failure to allege an interest in an enterprise demonstrate a failure to plead a common enterprise within the Howey factors. And that's why we cite not just Howey over and over again, which we do, but the cases interpreting it.
Well, to that point, I had 2 reactions going in 2 different directions. And one was, I thought you were about to step in the trap that Mr. Costello laid for you earlier, where he discussed how Coinbase's citation to or use in any way of the Howey test undercut its major questions doctrines argument, because the idea of, by acknowledging Howey, you're as the playing field on which these issues are to be resolved, you're necessarily suggesting that there isn't some void, some almost ultra-virus activity that the Commission is doing, which would implicate the major questions doctrine. So that's one thing to think about. Thing 2 is that I had a question to myself, which is to how your arguments applied, or was the logical extension of your arguments to be that there could be no common enterprise with respect to the 12 or 13 tokens. So we can save major questions for your colleague, who I know is going to speak to that, so she'll know to talk about that. But can you help me understand how, if at all, your arguments about the need for contractual or ongoing relationships, and I'm very much short-circuiting them by calling them just with those few words, I'm just sort of, evoking them for you, how that impacts the common enterprise analysis?
Well, I don't think it's impossible that a token could have those characteristics and satisfy the Howey test. And we said that in the abstract. We haven't talked about Judge Castell's decision in Telegram, but that is a really interesting case along these lines. It's a primary issuer case, and I want to be clear on that because it's suggested in the briefing that it's not, but the SEC was plain as day that it was, and I think the case is clear. But that was a situation where there was a contract right in the middle of the case. It wasn't anything like this, the Graham purchase agreement, and it provided for certainly a contractual undertaking, and one in which there were going to be payments made in tokens for the performance of the enterprise or the return of the investment if the blockchain wasn't launched. And that seemed to be a very reasoned application of all of this in the Howey prongs. It fit in a way because you were able to look at the way the funds were invested and see them pooled in a common enterprise, and you were able to see the contractual undertaking that made for the return. Many of the cases, however, that are shoehorned into the complaint and might otherwise be litigated just can't fit. And one of the things that caused us to think a little differently about Howey, Your Honor, is that in this case is that it's a unique case, and I use that word advisedly, where the SEC alleges that an investment contract changes hands on a secondary market. That's new. And it fits very, very, with real difficulty analytically with Howey, because Howey was a privity case, a primary issuance privity case. Nearly every single one of the cases that followed it was a primary issuer privity case. The only one that wasn't was maybe the Hocking case, which we've talked about in our briefs. I won't bore the court with, but it seemed in the context of a secondary transaction very difficult to shoehorn a blind transaction that required a contractual undertaking into the Howey analysis, which I do think fairly said wasn't built for that. But I want to be clear, we have no fear of Howey. It's a case that says an investment contract requires a contract. It actually says that the investment contract anticipates an investor taking shares in an enterprise, and it says repeatedly that those shares are to be evidenced by contracts and deeds, and those contracts and deeds should determine the future payout due investors. That was Howey, and that's our case.
Good counter argument. That was really good.
Speaking for a moment, going back to Terraform and also Judge Barbadoro's, I believe it's called library, LBRY, at least that's what I was told at our last oral argument. I thought I understood, and at least it's been suggested to me, that I should understand those cases to stand for the propositions that what mattered for purposes of whether these were investment contracts or whether it's securities was whether the tokens were marketed as profitable investments and whether the profits were derived from the efforts of the issuer's management team. Now, neither of your issues, either an enforcement, a means of enforcement, or a sort of an ongoing interest or relationship is present. Has the argument that's been made to me, does it just overlook important things of Terraform? You've already talked about Terraform. Perhaps library is the place to talk.
Well, I mean, I guess I do want to emphasize that library, if that's how it's pronounced, is a pure ICO primary trading case, and that's a very important point of distinction. And because it was an ICO case, the matter of the contractual undertaking was much easier to resolve, and there were findings there about the way those proceeds were invested to launch the enterprise. On the subject of our slides, I'll just let the court draw the court's attention to slides 10 and 11, and we think this is really important because we don't think these cases, which had only to do with the ICO context, the initial offering context, the primary privity context, can be imported into the secondary arena. In the briefing, the Commission suggests that they stand for the proposition that primary and secondary transactions ought to be viewed in the same way. In every one of these cases, the Commission stood up and told the judge, we're not talking about secondary trades, they're different. Each one of them, including, as on the last slide here, 11, you can see that the judge even seemed quite frustrated about it every time he raised the matter of secondary transactions. We're not litigating that here. The Commission has to decide that, blah, blah, blah. And then the court said,
That's the transcript, huh? Yeah, that's awesome.
Right? Have I misunderstood your position? No. And so those cases, they're just not opposites here. They concern very different factual practice.
Okay, thank you. I'd like to give you a break, please, if I could turn to your colleague, Mr. Schwartz, to talk about why my discussions with Mr. Margita about wallet and staking were all wrong. Thank you, sir.
Not all wrong, Your Honor.
Okay, great.
Your Honor, we'll start just by saying that there are actually I'll start with wallet if that's comfortable. There are actually very few allegations put at issue in the wallet claim. And as you heard from our friends at the front table, the law is well settled and the parties aren't disagreeing about what it is. We both cited the same 9 factors, and I think there's no real dispute that nearly all of them are absent from the SEC's allegations. They don't dispute that they haven't purported to allege the variety of core brokerage activities that are traditionally found by courts, negotiating terms for the transaction, making investment recommendations, arranging financing, holding customer funds, conducting independent asset valuations. None of these core factors are addressed at all, even purport to be alleged. What they do say they alleged, and that's what I want to turn to, As my colleague said, you may find it helpful to look at page 15 in the deck. This just sets out on one slide for you, so you can see the 4 paragraphs in one place that the SEC points to as sufficient pleadings to survive the motion for judgment on the pleadings. We think these fail as a matter of law to support a claim that Wallet acts as a broker. I'll point you to 64 and 82 to start. Those together talk about Wallet routing customer orders through third-party decentralized exchanges. Assets from blockchain developed a swap via Wallet, price comparisons across multiple exchanges. What you don't see in these allegations, Your Honor, are any well-pleaded facts showing that Wallet itself is doing any of these activities beyond allowing users access to the third-party platforms who give that functionality, who carry out those activities. And here, Your Honor asked about this earlier, and we want to direct your attention to it indeed. The user agreement, which is incorporated in the complaint by reference, lays this bare. The bottom line that it's not Wallet, but it's third-party platforms that are carrying out the very activities the SEC is referencing. And here, if you turn to slide 16, Your Honor, you'll see the portion of the Coinbase user agreement excerpted for you, setting forth what happens in Wallet. The app or browser provides a link to the platforms. Through the link, users, quote, navigate away from the Coinbase site to the dApp or the DEX. And, Your Honor put it very well in the Uniswap case. Once Wallet provides a technical connection to the third-party platforms, customers then direct the smart contracts on those platforms, like the Uniswap trading platform, to take the digital assets out of Wallet and carry out the swaps or whatever activity those exchanges permit. There are no well-pleaded facts to the contrary here, suggesting that these activities occur within Wallet itself. And I'll just add, Your Honor, there was an earlier colloquy about 0x, which is yet another one of these third-party exchanges. It's an information-based protocol that connects up to third-party platforms. That is not within Wallet. It's not alleged to be within Wallet, by the way. My colleagues at the front acknowledged that was noted in a footnote on page 27 of the brief. It was not alleged in the pleadings. But I'll hasten to correct it anyway. 0x is one of those third-party platforms to which the Coinbase Wallet, the user interface, connects those users to do activities on a third-party platform. And that's a critical correction or clarification in light of the limits of the pleadings and the user agreement that's fairly before the court. Another activity they point to in paragraph 75, you had a discussion about earlier, was solicitation of investors as something that was purportedly alleged. If you look back at paragraph 75 again on slide 15, the allegation is that Coinbase solicits customers by advertising features of Prime platform and wallet. Advertising to download the software. That's nothing like the findings that courts have made for solicitation of investors for particular investment transactions. That's the broker solicitation courts have addressed in the cases the SEC points you to. Hansen, Martino. In the SEC's brief, those cases are ones that identified as brokers agents of issuing companies who actively targeted prospective investors to raise capital by touting particular investments. None of that is alleged here. And so here again, I think it's fair to consider solely the limits of the allegation and the absence of well-pleaded facts, adding anything of this sort to solicitation of investors to conclude that this too is not alleged as one activity. Lastly, you had a discussion about paragraph 101, the last one listed on slide 15, that Coinbase used to charge customers transaction-based compensation for the activities on those third-party platforms. Coinbase no longer does charge for those activities, but even if it did, it's important to say the courts have been crystal clear, and it's long been true, commission-based payments standing alone do not make brokerage activities. And that's
okay,
not
but in fairness, they're not suggesting that the commission standing alone would have made Coinbase a broker. They are suggesting that what you say is providing access to third-party apps, DApps, and things like that. That's what I guess the concern I have.
Absolutely true. Yeah.
Right. So the concern I have is you all seem to have a dispute about the facts. I think I'm hearing you to tell me that I can resolve that dispute in this context because the user agreement and other statements, when compared with the paucity or the abstractness of the Commission's allegations, no offense, is enough to allow me to find as you wish me to find. But I think they're saying, not yet, Zala, you've got to let this go through to discovery.
Yes, Your Honor.
Okay.
I think that's exactly right. With respect to the allegations in 64 and 82 that we talked about, that paucity, saying that Wallet does something through third-party platforms, that something happens via Wallet, that the price compare happens on us, each of those is the circumstance you just described, where the paucity plus the user agreement gives you ample basis to decide the pleadings don't suffice. But where I'll round out the picture is with respect to the solicitation of investors, the only other core broker activity the SEC claims to have even alleged, that on its face does not allege what is understood as a matter of law to be the solicitation of investors by brokers.
I see. I appreciate the clarification. Thank you. Let me just take a note of that.
This isn't looking good for the SEC so far.
Yep, the judge's been super favor of Coinbase so far, really lining it up very positively for Coinbase so far.
Our next question of Coinbase, then we'll get to summary arguments.
Your Honor, in case useful, I mean, it occurs to me from your discussion, one way that the SEC has sought to suggest there's an alternative frame or some different version of facts is by saying the user interface connects and therefore facilitates, it puts these parties together. Again, this is not a fact dispute. As a matter of law, that facilitation or putting parties together does not make brokerage activity. And I'll point Your Honor's attention to a case in our briefing, the Reed case. This is also found in the Foundation Ventures case. But Judge Lyman in the Reed case made clear merely providing information or bringing two parties together to make their own contract does not transform an individual entity into a broker, even if they receive commission-based payments. At most, it's the activities of a finder, and that is not subject to the securities laws. In that case, the person at issue didn't negotiate the transactions, didn't engage in substantive conversations, give valuation advice, the variety of core activities I mentioned that aren't even purported to be alleged here. And so,
fair enough, sir, but I think the concern of the Commission, and it might be a concern that I share, is to the extent that what we're talking about is how you can implement technology to make things faster, easier, have access to even more entities. There's a concern I believe the Commission has that it can't just be that technology obviates a finding that one is a broker, because if what you do, if you do broker-y functions, but you do them through some sort of automated mechanism that you have at your disposal, you might still be a broker. I think that's what the Commission is saying. I think what you're saying, and let me just confirm that, is that the allegations that are contained in the pleadings, as amplified or perhaps given further detail by the user agreement, are just not enough. Am I understanding your argument correctly?
I think that's exactly right with respect to those activities that the Commission claims to have alleged.
Okay.
And there's no dispute about the variety of core activities they don't claim to have alleged that I mentioned at the outset.
Right. So there are a number of factors that I may consider in determining whether someone is acting as a broker. You're saying they don't allege all 9 or whatever, they allege a couple, and as to those, there are reasons to disbelieve or to view with skepticism the allegations that are made.
Yes, we would say there's reason to find they're not well-pleaded facts to support those allegations.
Or that. Okay, thank you. Shall we then speak of staking, sir?
Yes, absolutely.
Are there slides about staking?
You better believe it, Judge.
Okay.
I will turn your attention. In fact, I hope it's helpful. Slide 17 was designed late at night, bearing in mind and reflecting on the last time we all gathered. And so I'm very glad to give it some attention. Your Honor asked a question, about what's properly before you when it comes to staking back in July. And that's why we thought it might be worth stepping back to frame what is properly at issue in the pleadings when it comes to the staking product. And to be clear, we think there are 3 different reasons, each sufficient on its own for this claim to be dismissed. But I'm going to start with the investment of money. And let me frame this for you. We've set out here the various provisions from the allegations in the complaint complaint and from the user agreement, which we think suffice to give you the picture of the facts that are relevant for disposing of these pleadings. At the foundation of the blockchains is the need to validate each new block or transaction that's added before it's added to ensure the security and accuracy on a consensus basis. You can see that in paragraph 312. Where staking comes in, Your Honor, is from two propositions, again, set out in the sources before you. Number one, blockchains that use proof of stake to achieve the consensus I mentioned set a fee, they call it rewards, that they pay to token holders to perform this critical validation service. That's set out in paragraphs 312 and 313 of the complaint. Number two, the users who take on this validation service to put up or stake some of their tokens while they're performing the validation service they get paid for. Paragraph 313 calls these staked assets collateral. Collateral against improper validation and collateral that's held in the protocol while the services are being carried out. For token holders who stake on their own, Your Honor, that's it. It's a fee for validation service for the blockchain. And you can identify that, again, in the allegations before you, confirmed by the provisions of the user agreement. Some users then choose to subcontract that service to Coinbase. They hire Coinbase to operate the IT to validate on their behalf, and they direct Coinbase to stake their tokens on the blockchain while that happens. Those are the facts from the complaint and the user agreement. And with these in hand, we think you can turn to each of the two reasons. We'll start with the investment of money, of why the complaint fails to plead an investment of money under Howey. And I'll begin, Your Honor, just with a case that the SEC, emphasized to you, the Rivera case from the Ninth Circuit. The Court of Appeals there said one has to, quote, commit assets to the enterprise in such a manner as to face the risk of loss. And I want to focus on the first part of that. Commit assets to the enterprise to have an investment of money. Sounds straightforward. Without a contribution of assets to the capital structure, there's just no investment. Here, the SEC has made no allegation. There's no plausible claim that they could, that staking customers commit anything to Coinbase in this way. They just direct Coinbase in the normal custodial relationship to make their tokens available to the blockchain as collateral, as paragraph 313 puts it, for potential slashing for error validation, and to provide IT services in connection with it. Now, the sole way that the SEC tries to satisfy this commitment of assets requirement, I'll point you to slide 18 for this, just to put their allegation in front of you. Paragraphs 340 and 341 and repeated elsewhere, is to tell you staking customers tender and just give up control over their tokens to Coinbase. And, here going to your question earlier about, where something is wrong but properly before you to resolve, center stage, Your Honor, this bare allegation warrants no credit and it's contradicted by the user agreement. You can see on the next slide, slide 19, section 2.7.3 of the user agreement and the appendix, which establish you, the customer, control the digital assets held in your digital wallet, and Appendix 4 extends this to staking services, whether or not the digital asset is staked. And this is important, in granting a motion to dismiss the Underwood complaint against Coinbase, Judge Engelmeyer addressed the same user agreement. And much as Your Honor described earlier, said where a document is incorporated by reference, the court need not accept contrary allegations in the complaint that seek to elude the facts contained in the incorporated document. His words were, the user agreement checkmated those plaintiffs from adequately pleading their claims. And Your Honor, you won't be surprised to hear, we think you should likewise find the SEC's bare allegations that customers give up control over staked tokens in order to claim there's a commitment of assets. It's checkmated by the user agreement. And taking that aside, there are no well-pleaded facts suggesting that anything about this relationship, this fee-for-service relationship that users have with the blockchain and they subcontract to Coinbase, there is no commitment of assets. There is no contribution of capital by the users to Coinbase's capital structure that could possibly satisfy the investment of money requirement that Rivera and courts have long required. Another aspect of staking you asked about, Your Honor, unless there's a further question about that, is risk. We spent some time in colloquy about risk. And that goes to the second half of the Rivera, of the sentence from Rivera, again, that the SEC is trying to rely on.
Well, are you suggesting that it's wrong for them to rely on it?
No, I think it's the right case to rely on. It just doesn't help them. Unfortunately, their allegations fall short of that standard of law. And here again, I'll just quote you the back half of what we said. An investor must commit his assets to the enterprise in such a manner as to subject himself to financial loss. And it's not just the Ninth Circuit. The Second Circuit has affirmed that the Supreme Court added this limiting requirement as well. Now, on slide 20, Your Honor, you'll see the handful of paragraphs that the SEC tells you suffice to allege risk of loss from staking. And I'm happy to take you through them. I'll tell you broadly speaking, apart from the conclusory allegation at the top, the first two, 341 and 343, concern blockchain requirements for staking and validation. The bottom two don't concern staking. They're just risks that are general to token holders. Both buckets of these allegations fail as a matter of law to assert risk of financial loss in the commitment of assets to the Coinbase enterprise.
Let me ask you to pause for a minute, sir. I've spoiled myself a little bit by looking at the next slide, it's slide 21, which speaks about the risk of loss and how it's discussed in the user agreement. My reaction to reading the briefing was that I thought that Coinbase argued in a number of ways that the risk of loss was infinitesimal, or that the risk of loss was something that could be addressed or made up for by Coinbase if anybody lost money, or that the risk of loss was the same if you were self-staking, or that the risk of loss was something that you'd have just as a customer of Coinbase, irrespective of whether you staked or not. But all of those arguments, they sounded to me a little bit defensive because they all seemed to presuppose that there was a possibility of loss. If the Ninth Circuit test that we're saying is the right test to use is that the risk of loss is itself enough, then the fact that the risk of loss is really small, could be made up, or it could happen in other circumstances, I'm not sure it gives me a complete answer. Can you help with that?
Thank you for the question. It covers the waterfront really well, and so let me try to take it in a few pieces if I can. Let's distinguish the two buckets, if you will, those that relate to staking in some way and those that don't. Because I don't think we would say that the risk is just so small you don't have to worry about it. The risk of loss does not exist on the pleadings and the user agreement before you. The first risk they point to is slashing, Your Honor, this idea that there could be improper validation and the staked assets are slashed. But that same paragraph, 343, acknowledges that is not a risk that Coinbase stakers face. It doesn't say it's small. It's not a risk that Coinbase stakers face because Coinbase indemnifies for it. Now, they go on to say there's still general risk. I'll just flag for Your Honor that quote in the rest of 343 is from a money transmission disclosure that Coinbase has for New York State, where paragraph 333 of the complaint acknowledges Coinbase does no staking business. So that quote has nothing to do with staking. So there's a discussion about slashing risk. Coinbase indemnifies for it. The allegation acknowledges that risk does not exist. The second risk that's talked about in 341 is a risk of loss while staking because tokens can't be used for other purposes like trading or transferring. And here again, this is just restating a condition imposed by the blockchain that the validators who choose to sign up for this service and perform this service for the blockchain in return for a fee put up collateral while they're doing the service. Think of it something like a security deposit. They're not going to do a bad job. They're not going to make mistakes while they're there. They get it back at the end. There's the allegation of risk that they can't do other things with their collateral, their security deposit, doesn't state a risk of financial loss that Rivera was talking about in such a manner from your investment. The last two, again, I think Your Honor summarized it very well. 344 and 345 are just not staking risks. They're risks alleged for anyone who holds tokens. Now, the way the SEC frames that as a defensible and sufficient allegation is to say that there's a risk of ownership loss for all token holders, and they don't have to allege more. And I want to tell you why that's wrong, Your Honor, but first, as you saw in the briefing, we do take issue with and dispute that standard of law. That's exactly what courts have to show, is that investors put capital into a business with the risk that its performance may lead to their inability to recover the capital. That's what investing in such a manner to face the risk of loss is, according to Rivera. And, stepping back, here the SEC is charging Coinbase with offering an investment contract through its staking service. To have an investment of money that's required for that, there has to be a risk of loss alleged that arises.
All right, guys, I'm going to leave this audio feed here. You guys can head on over to Meet Kevin's page, who's obviously a big YouTuber. He's streaming this as well. If you guys want to carry on watching this, I'm going to go post some new trades inside our VIP community. We're going to take some new trades. So I'm going to jump in and post a new trade in there. If you guys aren't in our Telegram community, ijazcrypto.com/TG, if there's any big announcements, I will share it. There's a chance that this case could go over until tomorrow. So let's wait to see what happens. They may rule on it today. They may rule on it tomorrow. Either way, it's a big step for crypto, right? We hopefully, Coinbase can do a good job. The judge was leaning towards Coinbase and being very polite and amicable with Coinbase, so that was looking positive for Coinbase, but let's see where it actually ends up in the final ruling. Thanks for joining me, guys, and I'll see you